In 1982, I'm sure we have people who weren't born then, I was a law clerk, and it's wonderful to be a law clerk, but you also have to immediately start looking for your next job, which I was. And I had a background in finance, and I'm a CPA, and so I thought, well, I would be a perfect commercial litigator, so I thought. And I was interviewing with the Chicago law firms, the large ones, and to date myself further, the largest law firms then had about 230 partners in them in the Chicago area, to show you how things have changed. But I needed litigation experience, I thought, and so I applied for the Attorney General's Honors Program. And lo and behold, they wanted a 4-year commitment. Well, when you're 27 years old, 4 years seems like a lifetime. And I very much wrung my hands over that decision if I wanted to give 4 years of my life to public service. And so here I am, approximately 36 years later. But I guess what I want to say is it's gone by very quickly. I have enjoyed it immensely, and would not have traded it for any other opportunities in the world professionally, showing how little I know. Which leads me to a public service announcement within my public service announcement, which is the Office of General Counsel at the FBI. We have 194 attorneys in 3 branches: litigation, national security, cyber law, and the investigative administrative law branch. They deal with a large number of issues, just like any corporation would. We have 37,000 employees and 18,000 contractors. We normally have about 15 vacancies. There's a rigorous process with a polygraph and a background check. It can't be that hard because I passed it. But we're always looking for smart, ambitious attorneys looking for an exciting career. And you will not find a better mission at any company or institution in the United States protecting the American people and upholding the Constitution of the United States that greets our employees every day when they walk into the building, the Hoover Building. The FBI has been in the news on occasion lately, and there are some topics I will try and discuss, and I'll try not to run out the clock so that Harvey can give me, won't have to give me perhaps, the hook sign. But I'm going to talk about the recent Fisk opinion concerning our query procedures, the USA Freedom Act, and cyber, if we have a chance to get that far into my remarks. So the recent court opinions on FBI minimization and querying procedures, Judge Boasberg, who's I think you're going to hear from tomorrow, found, so he gets rebuttal time, found that our revised procedures that we submitted were not appropriate. The querying procedures were inconsistent with the requirements to keep records of each U.S. person query term, and it was inadequate in our query justifications, and they were inconsistent with Section 702E and the Fourth Amendment. So the amended procedures, which have now been approved by the court, we will retain querying records in a manner that differentiates between U.S. person queries and all others, a written justification for a U.S. person query before the agent or the employee reviews the content retrieved by the query, and we're in the process of making technical changes to the systems and the training that we provide to our agents. But I would like to talk a little bit about some things involving our query procedures and the opinions that are not in the opinion. So right after the Fisk issued its opinion, Director Wray ordered the creation of a compliance review team to review Judge Boasberg's opinion and evaluate how we can improve our querying procedures. The point is, the FBI takes very seriously its responsibilities, and we took this as a proactive step, separate from our decision to appeal the Fisk ruling, because of our commitment to compliance. the director frequently says, and I've heard him say it dozens of times, we need to do the right thing the right way. And that was all in his efforts to do that. We believe it's important for the FISC, Congress, and the American public to have confidence in our procedures and our compliance rate. As I said, Judge Boasberg has approved the modified procedures with new requirements, which means we're now consistent with the Fourth Amendment and FISA. Nevertheless, the compliance team will continue its work and evaluate whether additional steps beyond our new compliance can lead us to address further concerns. Judge Boasberg's opinion discussed the FBI's policy on queries because it is routine and an encouraged practice for the Bureau to query the Section 702 collection in furtherance of authorized intelligence and law enforcement activities. And Judge Boasberg recognized that there is a tension created between encouraging FBI personnel to routinely query the collection in order to proactively identify threat information in the collection and the need for those personnel to comply with the query standard. But most of the compliance incidents cited in the FISC opinion involve efforts by the Bureau to be proactive and identify threat information that we were holding in our collection. Some of those compliance incidents involved what we would call threat identification queries, where FBI personnel attempted to proactively identify threats that the Bureau was unaware of. One of the compliance incidents involved queries of identifiers associated with individuals who were in a position to exploit what the Bureau believed was a vulnerability. Other incidents involved proactively vetting specific individuals in order to determine threats posed by disclosing classified or sensitive information to them. Those incidents involve potential confidential human sources or potential recipients of classified FISA orders. It's important to remember that the FBI's policy of encouraging queries of our collection is born out of lessons learned from 9/11 and the Fort Hood attack. The 9/11 Commission and the Fort Hood Commission both talked about the importance of identifying threat information in the FBI systems and encouraged the Bureau to develop a federated search capability to facilitate the identification of threat information queries. Historically, the view has been that the more queries the Bureau runs, the greater the likelihood it will identify threat information. But we recognize that it's important that every one of those queries has to be consistent with our procedures. The FBI has to strive to stay within that middle ground where we are aggressively looking for threats to the American public in our 702 collection without violating the query standard. If we're not aggressive enough, the American public is at risk. If we're too aggressive, we will have compliance incidents and erode the confidence that we so need from the FISC, Congress, and the American public. And that is why the middle ground is so important, and we're committed to staying within it. As I noted, the compliance review team will continue to carefully consider the FISC's concerns about our query policy while being mindful that to change that policy potentially could impact our ability to identify threat information. The FISC also identified what it called complications in applying the query standard and suggested that Bureau personnel may not necessarily understand the reasonably likely to retrieve standard. That is, a query has to be reasonably likely to return information of a crime or foreign intelligence information. That standard is fact-intensive, which means the application of the standard can be challenging and reasonable minds can disagree. The most obvious way to address that concern is through additional training, which has been one of our focuses for some time. For more than a year, the Department of Justice and FBI attorneys have been giving in-person training on the query standard to FBI personnel at various field offices. The FBI also rolled out new mandatory FISA training that will focus on the query standard. That training is designed to enhance personnel's understanding of the query standard and help them differentiate. The compliance review team will continue to evaluate whether additional steps are necessary after our new program goes fully live in December. A couple of words about the USA Freedom Act. It expires in December, which I assume most people know, and it has three primary authorities as concerns the FBI. Section 215, business records, roving wiretaps, the lone wolf provision, which applies to non-U.S. persons and international terrorism with no requirement to show a connection to a foreign government. I'll go a little bit more detail into all three of those. As I said, they are all expiring, and the tools are critical to what we have available for our national security investigations. The Bureau has a solid years-long record of successfully using both the business records provision and the roving wiretap provision. These provisions are integral to our investigations. They provide the building blocks in many cases and the ability to keep pace with the threat and to avoid missing critical intelligence. The business record provision deals primarily with transactional events. That is, electronic communications, transactional records, business records such as hotel receipts, storage facility receipts, and flight records. These types of records are collected in virtually every single criminal case. The FISA business record requests are court reviewed. In all cases, the FISC must find there are reasonable grounds to believe the records are relevant to an authorized investigation. In almost every respect, these requests are similar to a grand jury subpoena that does not undergo court supervision. Likewise, the roving wiretaps are subject to court approval and supervision. The FBI has to show a specific target of a FISA investigation order engages actively in activity that is thwarting our surveillance. If the FBI makes such a showing, the FISC can authorize surveillance that will allow the target, even if he takes steps to avoid that surveillance, such as burner phones. Again, the roving authority is substantially the same as that which is used in a Title III wiretap. The lone wolf provision, as I indicated, is very narrow, but its limited applicability does not diminish its possible utility. Lone wolf can be used for the surveillance only of non-U.S. persons. It allows the Bureau to obtain a FISA order targeting a non-U.S. person engaging in international terrorism or the preparation thereof, even if the Bureau cannot show the target is doing that on behalf of a foreign power. And that is its real advantage for us. We all know that self-radicalization is on the rise. We're seeing more and more homegrown lone actors. These extremists can be inspired to act on behalf of a foreign power, such as a terrorist group, but rather than being directed to do so. This increases the likelihood that the FBI will need to rely upon the lone wolf provision in the future. Now I'd like to move to cyber just a little bit. People frequently ask me what has changed in the practice of law in the 37 years that I've been a lawyer. And that's always been a very easy answer for me. There are two things. One is digital evidence and just the digital footprint that affects us all. Instead of at one time talking about evidence as a number of boxes, and 30 boxes is a big case, Now we talk about gigabytes and terabytes. The other aspect that I'm not going to address today, but certainly is part of your program, is the international effect. Back in the mid-'80s, when we had an MLAT, that was a big deal. I mean, that was something else when you had an MLAT. Now it seems as though almost every investigation, whether national security or otherwise, involves some type of acquisition of foreign evidence.
You may explain what an MLAT is, because we have some people from the Marine Corps here.
Okay. An MLAT is a mutual legal assistance treaty, which is, in my view, a somewhat cumbersome process that allows us to receive evidence from a foreign nation. And it takes a great deal of time, and in fact, that is really part of what was the impetus for the Cloud Act, which we're hoping, and we'll see, the devil is always in the details, as we move forward with the Cloud Act, if it solves some of those problems and makes the acquisition of foreign evidence easier, which is our hope. So cyber and encryption challenges. The challenge is cyber and technology are enabling criminals and foreign adversaries. There are new venues of attack, greater attack surface, from any location near or far from our target. There's a low-cost barrier to entry. It's easier to mask or hide the attribution, and the tools are cheaply and widely available. There are cyber mercenaries who will hack for hire. This affects everyone, even those who may never own a computer or a cell phone, because the attacks are on the power grid, our critical infrastructure, on third-party protection of PII, the OPM as an example, health records, and financial records. All of this occurs against a background which has many tools for cybersecurity. The technical tools of encryption, antivirus, firewalls, multi-factor authentication, vulnerability patching, cyber threat hunting and air gapping, the legal restrictions of NDAA bans, sanctions, CFIUS, supply chain requirements, regulations, and contractual agreements, policy and process, social media, and the terms of use policies, incident response plans, identity authentication, identity management, dual approval requirements, and restricted access. The training that all of us do each and every year in all of our entities, information sharing that we have on these threats. But a lot of focus today is on the issue of legal access. And I will echo some of Attorney General Barr's and Director Wray's recent statements. Encryption impacts privacy, cybersecurity, and real-world security. Encryption provides privacy and cybersecurity benefits. More secure communications, networks, data storage, online transactions protects personal information. But encryption also enables terrorists, criminals, and foreign adversaries. It allows the sexual exploitation and abusing of children. It is those conspiring to commit crimes or planning terrorist attacks, radicalization and recruiting, stealing intellectual property, and undermining our democratic values and institutions. Encryption leaves service providers unable to produce readable content in response to lawful court-ordered requests, wiretaps, or search warrants based on probable cause. I'll repeat that. They cannot respond to court orders for readable content. It impacts communications in transit or stored in electronic data. It degrades the ability to detect and prevent, to arrest and prosecute. It creates a law-free zone for criminal behavior. As the Attorney General said, making our virtual world more secure, no one argues with that, but making our virtual world more secure should not come at the expense of making us more vulnerable in the real world. Barely a week goes by that the FBI is not confronted with an investigation impacted by the obstacle of encryption. And these are real concerns, real problems. The state and local law enforcement authorities are hurt worse because they have less tools or resources to address it. But these problems, concern Mexican cartels who use WhatsApp for encrypted communications to coordinate their drug shipments and the murder of police officers, terrorists, the 2015 attacks in Garland, Texas, where 2 Islamist extremists carried out an ISIS-claimed attack. One terrorist exchanged approximately 100 instant messages with an overseas terrorist using an end-to-end encrypted app. To date, the Bureau has still not been able to determine the content of the messages, which could provide useful intelligence. Gun violence, the 2017 church shooting in Southern Springs, Texas, where a gunman killed 26 people and injured 20 more, the 5th deadliest shooting in U.S. history at that time. Even with more advanced commercial tools, 600 plus days later, the Bureau is still not able to crack the code to access the gunman's phone. With today's tools and capabilities, it still could take years to unlock the device. Gang activities and murders, they use encrypted apps to greenlight assassinations. This is not a theoretical problem. But there is positive engagement we have to improve public safety. With access to such communications and with the cooperation or partnership with communication services and their platforms, we have achieved great success. General Attorney Barr and others have commended Facebook in his letter to his CEO, noting that Facebook made 6.8 million reports to the United States Center for Missing and Exploited Children, NCMEC. More than 90% of the 18.4 million total reports that year. Facebook acted against 27 million pieces of terrorist content between October 2017 and March 2019. More than 99% of the content Facebook took action against, both for child sexual exploitation and terrorism, was identified by its systems rather than users of reports. However, if Facebook implements its end-to-end encryption as planned, NCMEC estimates it will lose 70% of the reporting. 12 million reports globally would be lost. What is the way forward? Well, some have suggested that the government can use metadata. I can tell you from personal experience as an investigator and a prosecutor, metadata does not equal the value of content. Some suggest that we could use artificial intelligence to increasingly advance our use of metadata. That simply oversimplifies the problem, and it doesn't address the problem. Metadata cannot provide the same type or depth of intelligence that content can. No one in law enforcement believes metadata can replace content. And the metrics, quite frankly, don't speak for themselves. There's no barometer that can measure the value of cybersecurity against the value of preventing child abuse, mass shootings, and terror attacks. Absent legislation, we look to the technology providers to help provide public safety and access to information needed in criminal and national security investigation. American technology has the skill and the ability to determine how to best design products that will allow for lawful access when needed. as Attorney General Barr said, welcome to civil society. We regularly expect and often mandate, if necessary, that our companies take steps to ensure that their products and services do not impose negative externalities on the public interest. The Department of Defense does this when it implements its requirements for cybersecurity standards on all of its contractors. The NIST standards only describe cybersecurity goals. They don't prescribe the tools or processes. Each can be designed on its own approach to fit business and environment. But there must be an analysis of the relative cost and benefits to society. It's not reasonable to incur massive further costs to move slightly closer to a perfect cybersecurity optimality at the cost of a massive degrading of public safety. The FBI has started to hear from crypto experts, and there are solutions that can account for strong cybersecurity and the need for lawful access. We still have vulnerability in products, even with encryption. The residual risk of vulnerability resulting from incorporating a lawful access mechanism has not been shown to be materially greater than those that are already in an unmodified product. So thank you.
Thank you, Dana.